Okay, good morning, everyone, and welcome to today's employment law seminar. My name is Marty Rabinovitch, and I am a partner at Devry Smith Frank, and I head up the employment law group. And once again, welcome and thank you for joining us this morning for today's seminar. So we will have 4 topics today. We've got one speaker that you have seen before, my colleague Timothy Gindi, and we'll also be hearing from today two new lawyers that have not yet spoken at these seminars. We've got David Heppenstall and Graeme Oddy, so I'm excited for them to make their employment seminar debuts here. For the human resources professionals out there, this program qualifies for CPD hours. So my understanding is that after the seminar is finished, you will be emailed a code that you can use to claim your hours. And for any lawyers in attendance today, the program qualifies for 2 hours of substantive content with the Law Society. So don't forget to claim those hours. We will be looking today at 4 topics. The first topic is about infectious disease emergency leave, or IDLE, and we'll look at an update and considerations for employers. So basically where we are at with deemed IDLE. Is it a constructive dismissal or not? And how should employers be dealing with this? Then my colleague Graeme will be speaking about electronic monitoring of employees in Ontario. There are some requirements which are taking effect pretty soon, so this is a pretty timely topic. And then my colleague David Heppenstall will look at a recent Superior Court case called Henderson and Slavkin about once again, enforceability of termination clauses, and specifically this time, whether language in confidentiality and conflicts of interest clauses can render a termination clause unenforceable. And then finally, my colleague Tim Gindi will look at a relatively recent Supreme Court of Canada case called Northern Regional Health Authority and Horrocks, and will address the question of whether unionized employees still have the right to pursue human rights complaints in the province of Ontario. So here is an overview of the agenda for today. So we'll hear from the first 2 speakers right away. We will then take a break at about 9:45 for 15 minutes. And then we will then move forward with the 3rd and 4th topics. Now, at that point, at about 20 to 11, we will open the floor for a Q&A period. So on the topic of questions, you should feel free to submit any questions that you may have through the Q&A feature in Zoom webinar. And our speakers will try to answer as many of them as possible throughout the seminar. And then if there are any additional questions that you have, or if any questions have not yet been answered, we will use the Q&A period beginning at about 10:40 to address those questions. And then at the end of the Q&A period, we will conclude the seminar, and we should be finished by 11 a.m. Now, I have to say the most frequently asked question, I would say, in these seminars is about whether or not the slides will be available. And I'm going to preempt that one and answer it right now and say, yes, the slides will be available. They will be available on our firm website very shortly after the presentation. The other option that you have is, if you would like them emailed to you directly, you can contact me or contact any of the speakers, and we would be happy to email you a copy of those slides. Okay, and the presentation is being recorded, by the way, and will be available also on our firm's YouTube channel. So without further ado, I'm going to get right into the first topic here. And this topic is about infectious disease emergency leave. And here is my contact information for anyone who needs it. Okay, so this slide is a summary, or really it's an excerpt from the Employment Standards Act, which sets out the rules about temporary layoffs. But just to set the table a little bit here, before the pandemic, there were some employers who relied on temporary layoffs from time to time if there just happened to be periods where there wasn't a lot of work, and they wished to say to an employee, okay, well, we don't really need you for the next couple of months, so you're temporarily laid off. So in certain industries that would happen more often than in others, but that was generally how these provisions were thought about, and what temporary layoffs really were all about. But then when the COVID pandemic hit us in Ontario, I would say, early 2020, the first lockdown was in March of 2020. You had immediate issues because there was a huge level of uncertainty, and employers just were not sure whether they needed to keep on employees, whether there was going to be enough work. So in March of 2020, many employers were immediately thinking, okay, well, I think I just need to temporarily lay off a whole bunch of employees. So then these provisions under the ESA got a whole bunch of attention again. So basically, under the Employment Standards Act, you can temporarily lay off an employee for up to 35 weeks in a period of 52 consecutive weeks, as long as you're providing that employee with benefit continuation. Okay. But there are some caveats here, because there actually is no common law right to a temporary layoff. And that is something that the courts have held pretty consistently. So in other words, despite these very nice rules in the Employment Standards Act about temporary layoffs, in order for an employer to be able to rely on them, you really would need to have a provision in the employment contract which effectively permitted the employer to temporarily lay off an employee. And if not, if the layoff was effectively unilateral, it would be considered a substantial change in the employee's employment and would likely result in a constructive dismissal at common law. So in May of 2020, the government of Ontario passed legislation with respect to infectious disease emergency leave. Now, the first thing that this legislation did was it permitted employees to take an unpaid job protected leave for reasons related to COVID-19. And that's set out here in a couple of sections of the Employment Standards Act. These entitlements were retroactive to January 25th of 2020, and they only applied to non-unionized employees. Okay, and then there's also provisions about what I'll call deemed infectious disease emergency leave, and this is set out in a regulation to the Employment Standards Act. And effectively, what this means is that if an employer effectively reduced or temporarily eliminated an employee's hours of work, then the employee would be deemed to be on infectious disease emergency leave. So again, this is an unpaid job protected leave. And in April of 2021, there were some further amendments to the ESA. So the provincial government finally introduced 3 paid days for employees who were unable to work because of COVID. This is set out in section 50.1 sub 1.11 of the ESA. This is capped at $200 per day. Okay. It was retroactive to April 19th of 2021, and it continues until March 31st of 2023. So effectively, employees are entitled to 3 paid idle days if they're unable to work for reasons related to COVID-19. And the good news for employers is that you can be reimbursed for these payments through the Wsib if you complete the right forms and submit them, and a little bit more on that later. So the uncertainty in the law comes from deemed infectious disease emergency leave. Okay, because you've got Section 7 of the idle regulation, okay, which talks about a temporary reduction or elimination of an employee's work hours or wages because of COVID-19. And what that section of the regulation says is, well, in accordance with the Employment Standards Act, that is not going to be considered a constructive dismissal. Okay, and that, by the way, ended on July 30th of 2022. And then on the Government of Ontario's website, there is a statement that specifically says these rules affect only what constitutes a constructive dismissal under the ESA and not at common law. So the confusion was, okay, so if this deemed idle is not a constructive dismissal under the ESA, well, can it still be a constructive dismissal at common law? So here's an excerpt from the constructive dismissal piece here, section 7.1. Okay, and one of the factors, as we'll see, that the court had to look at was that in order for the common law to be altered by statute, there would need to be express language to this in the statute to that effect, and this is addressed in section 8 sub 1 of the ESA. So let's look at the case law briefly here about deemed idle. So again, this is when employees are having their hours reduced or their wages reduced for a reason related to COVID-19. So there's really 3 cases. You'll see that one of them, there's both a Superior Court case and a Court of Appeal case here. Okay. So in the first case, Coutinho and Ocular Health Center, this is 2021, there was an employee who was placed on temporary layoff due to a workplace closure during the COVID-19 pandemic. The plaintiff commenced an action claiming damages for constructive dismissal at common law. And the defendant employer argued that the idle regulation should apply not only to constructive dismissals for the purposes of the ESA, but also at common law. The Ontario Superior Court was asked to consider whether the idle regulation prevented an employee from advancing a claim for constructive dismissal at common law. And in Coutinho, the court said that the plaintiff could pursue that constructive dismissal claim. So effectively, the court determined that Section 7 of the regulation had to be interpreted in conjunction with Section 8 sub 1 of the ESA. So again, that the ESA is not meant to prevent any civil remedy of an employee being sought against their employer, and constructive dismissal in the civil courts is absolutely one of these civil remedies. The court found that the plaintiff was not pursuing their claim for common law constructive dismissal, and that the plaintiff was entitled to treat the company's unilateral imposition of the layoff as a termination, and that there was the right to sue for constructive dismissal. And then we get another case called Fogelman and IFG. The facts are somewhat similar to Coutinho, and the court determines the issue in the same way. The plaintiff is allowed to move forward with their common law constructive dismissal claim. And this time the court even references the Ontario government's excerpt that we saw a few slides ago, which specifically said that these new rules were not meant to address common law remedies, but were only meant to deal with the Employment Standards Act. And then we get a third case called Taylor and Hanley Hospitality. And this one was decided differently. It was decided by Justice Dunphy. And in particular for employment lawyers out there, Justice Dunphy it has quite the reputation for being pretty pro-employer. So perhaps not surprisingly, Justice Dunphy came to the opposite conclusion. He said, nope, there is no constructive dismissal at common law. That the regulation, in fact, was enacted to displace the common law of constructive dismissal, because what Justice Dunphy, I think, was struggling with was, you've got a scheme where you've got an employee who was on an unpaid job protected leave under the Employment Standards Act, but then if we allow a constructive dismissal complaint to proceed, well, then for the purposes of employment law, the employee is dismissed. They're not an employee. And I think Justice Dunphy was having some difficulty reconciling that, because it didn't really seem to make a whole lot of sense at some level. Anyway, so Taylor comes to the opposite conclusion, but then this case gets appealed to the Ontario Court of Appeal, which is the highest court in Ontario, and the decision gets set aside on other grounds. So unfortunately for employment lawyers and human resources professionals and employers, of course, the Court of Appeal declined to address this issue, despite the fact that the lawyers who were arguing at the Court of Appeal practically were begging and imploring the Court of Appeal to please address this important issue so we have some guidance on it. But ultimately, the Court of Appeal said, sorry, there's certain things that are missing in the record before us, so they didn't ultimately address the issue, and the case gets sent back to Superior Court to effectively be re-adjudicated. So what is the current state of the law? So we're basically left with Coutinho and Ocular, and then Fogelman and IFG, both of which were decided in favor of the employee, because the court found that common law constructive dismissal was an available remedy to the employee, despite the fact that they were on deemed idle. So ultimately, this issue is probably not going to get resolved until the Court of Appeal decides it. So it might be that Coutinho or Fogelman have to get to the Court of Appeal, or perhaps a new case will make its way there so that the issue can be decided. So on July 1st of 2022, so about 2 months ago, the ESA's regular rules around constructive dismissal resumed. Okay, so now there's no more deemed idle. Okay, so the question now sort of becomes, well, if there are any employees who are still not back to work, who were on deemed idle, how do we deal with those? So let's look at a few options for employers, and I'll just say that the best solution and strategy for an employer is going to depend on the facts and circumstances of the case. So please consult with your employment lawyer before moving forward. But just generally, some of the possible options would be to bring those employees back to work if you need them. So, on the one hand, maybe it's better late than never if they're not already back. But on the other hand, you would want to engage in some sort of analysis with an employment lawyer about whether the employee has already been constructively dismissed and how that is going to affect things. You could also formally terminate employees who were on deemed idle and provide them with a severance package just to end things effectively if the employer does not want that employee to come back. You could also consider putting the employees on a temporary layoff under the ESA, which at this point would be retroactive. So if you just think back to that very first slide, that excerpt from the Employment Standards Act about temporary layoffs, that's what I'm talking about here. So once the idle rules ended, okay, or the constructive dismissal rules ended, employers who do have temporary layoff provisions in their employment contract would be allowed to communicate to an employee that, okay, you're no longer on deemed idle, but now we're putting you on a temporary layoff. So that would be allowed, again, as long as you have a provision in the employment contract with respect to temporary layoff. So putting an employee on temporary layoff is also a possibility. Okay, and then finally, of course, you could just do nothing and effectively, let sleeping dogs lie, and hope that maybe the employee found work somewhere else, or for other reasons they're not interested in returning to work and not interested in suing you either, and then maybe the situation just goes away. As a practical matter too, the more information you have, the greater the chance of making the best decision, having regard to everything. So if you still have employees who are not yet back to work, you may want to check in with them and at least find out where they're at. Do they want to come back to work? Are they already working somewhere else? And once you have more of that information, then it'll be easier, I think, to make the best decision. So just a quick note here on the paid infectious disease emergency leave. So again, that's the three paid days if an employee can't work because of COVID. That continues until March 31st of 2023. Although to clarify, it's a total of 3 days. Okay, it's not a new 3 days beginning in 2023. It's a total of 3 days, including the period from which this started. Okay. And then just quickly about the reimbursement through the WSIB, the employer would need to effectively file the paperwork within 120 days of when the employer paid the employee, or by July 29th of 23, whichever is earlier. Okay, and these payments are capped off at $200 per day. Okay, it's basically meant to replace the employee's wages, but there might be employees who aren't quite earning $200 per day, in which case it would be less. So these are the criteria for the employer to get their money back from the WSIB. I won't read everything out here, but we're happy to help you with this if you would like. Effectively, you have to just show that you have made the payment. Okay. And that concludes my presentation. So thanks very much for your attention. If you have any questions, please feel free to post them in the Q&A box. And I am now going to turn things over to my colleague, Graeme, who is going to speak to us about electronic monitoring of employees. Graeme, all yours.
Thanks, Marty. As Marty said, my name is Graeme Oddy. I'm one of the lawyers here at DSF. Just put my slideshow up here. All right. So yes, electronic monitoring. So yes, just to get us started, why does this matter? Why does the government care? Why should any of us care about electronic monitoring? I would say electronic monitoring, it's more important than ever. First of all, as we all know, COVID brought working from home to the forefront of our minds. And the reality is that it's harder to monitor your employees when they're working from home or when you're working from home. So it's naturally become the focus for many employers over the last 2 years. Next, many employers have legitimate business interests in monitoring their employees. There's the typical, what you'd think of, has your employee even turned on their computer? But it's not just that, there's how long things are taking, there's efficiency questions. A trucking or delivery company, for example, would want to know, is their driver en route? Where are they? How long shipments are taking? There's safety considerations for your employees. Customer service is engaged as well. If your employee has a negative interaction with a consumer, Sometimes it's necessary to record those interactions and be able to say who was in the right, who was in the wrong. And finally, with advances in technology, software, hardware, networking, cloud computing, all this has made it easier than ever to monitor employees. And evidently, the government believes that there should be some transparency about what's going on there. So all that to say, it's important. It's not going away. The law is here, and we have to deal with it. So let's look at the legislation itself. The ESA was amended on April 11th, 2022 by Bill 88, which was also known as the Working for Workers Act. And the relevant sections can be found at Part XI.1, Section 41.1.1. The link's in the slide, which you will receive. Who's affected? So if you have more than 25 employees, you're required to have a written policy which addresses electronic monitoring, and you have to provide copies to your employees. If you have fewer than 25 employees, lucky you don't have to worry about any of this. The count includes temporary or agency workers, even if they're not under your direct employ. And it's total employees with an employer. It's not based on a specific workplace location. So if you have 3 workplaces, you have 9 employees at each location, that's still 27. You still need a written policy. When is that 25 employee determination made, and when does your policy have to be in place by? So if you had 25 employees as of January 1st of this year, then you have until October 11th to have your written policy. And then you have 30 days after that to provide it. So you have to give your employees a copy of that policy by November 10th. Starting next year and every year after that, if you have more than 25 employees on January 1st, you have to have a written policy before March 1st of that year and provide it to them 30 days later. If you make any changes, you have to distribute copies of the new written policy, again, within 30 days. So what do you have to put in it? First thing is whether you're going to actually electronically monitor your employees or not. If you're not going to do any monitoring, but you have more than 25 employees, you still need a policy. It can say, we're not going to electronically monitor. That can be the end of it. If you are going to conduct electronic monitoring, or you think you already are, the next question is how that monitoring is going to occur. So what exactly are we talking about here? Somewhat unfortunately, electronic monitoring itself isn't defined by the law. Government has published some guidance to accompany the legislation. You'll see the link there as well. But basically, the best they could do was define it as all forms of employee monitoring done electronically. So it doesn't really narrow it down. So as I said, there's some obvious examples: keyboard use trackers, mouse use, location tracking, website and search history, review of employee emails. If you plan on doing those things, should be set out in the policy. And you're also expected to explain how the monitoring actually takes place. So is it a manual review? Are you using some kind of filter software to sift and sort through a person's emails or history? Are you running a program on devices for a specific purpose? Or I would suggest it might include, are you even using some kind of Salesforce type of data amalgamation and analytics software? It's also not just about the use of personal devices. You have cameras installed at your workplace or in a vehicle, or if you have a GPS tracker in a vehicle rather than a mobile device, that should be set out as well. So now you might be thinking, that's a lot of stuff, and it is. And that's why I say it's somewhat unfortunate that as it stands now, it's kind of undefined what electronic monitoring means, or it includes pretty much everything. And I want to get into this a bit more later on, but right now I'll just give you 2 examples of why it's a little unclear, and that's in the context of what you might call passive monitoring. So if you give your employees mobile devices with GPS tracking software in it, and you could track your employees' locations at all times, but no one ever actually looks at the location information, does that count as electronic monitoring? Maybe. Or, and this is totally common, your workplace has a server which backs up all employees' emails, all their files, web traffic history, etc. But no one ever looks at that information and no one intends to. So the data is there, no one looks at it. Is that electronic monitoring? My answer is it's not particularly clear at this point. So for employers trying to craft their policy, this lack of definition definitely makes things a bit more complicated. So once you've determined how your electronic monitoring is happening, if you can, the next thing you have to set out in your policy is in what circumstances may the monitoring take place. So are you being monitored while you're in the office, while you're working from home, or both? Are you being monitored on your work devices or your personal devices, or both? Is there a time range? So is it just during work hours that you're being monitored? Is it 24/7? All this information is supposed to go in your policy. So you're collecting data. What are you going to do with it? So your policy has to set out the purposes for that you plan to use the information. So are you collecting data, as I was talking about earlier, for efficiency, just to make sure people are actually working, to know where your employee is, to make sure company resources are being used properly, to assess performance or potentially discipline an employee. Whatever those reasons are, those should be in your policy. Your policy has to include its date of any revisions, and finally, the legislation says the policy has to include any other information as may be prescribed, leaving the door open for change by further legislation or through interpretation by the judiciary. Another note, the guidance says you don't have to have one all-inclusive policy. You can have numerous policies which apply to different categories or types of employees. The larger your workplace is, the more likely this is going to apply to you. For example, if you have a truck driver, you have a bicycle delivery person, you might want to know where they are, how long it's taking them to get around, but you wouldn't care about that information for, someone who's in the office or sitting at a computer. But you might want to know whether your office staff actually has their computer turned on, but you wouldn't care about that for a truck driver. And I may be being optimistic here, but I view this as actually something that might be helpful to employers. By going through the exercise of crafting several policies, you'll be able to identify what information you do care about and not end up devoting a bunch of resources to tracking information that doesn't matter or that doesn't apply to a subsection of your workforce. So what does this mean for you? These are some expected questions and their answers. How do you have to give it to your employees? So you can provide it as a printed copy. You can provide it as an attachment to an email, if the employee can print a copy of the attachment, or you can provide a link to the document online if the employee can access the document electronically, has a printer, and knows how to use both a computer and a printer. Can employees complain or file an employment standards claim about their policy? Yes, they can, but only with respect to the employer's requirement to provide a copy of the policy to their employees. As it stands now, regarding the contents of the policy, the scope of the monitoring, the use of the data, employment standards officers have no jurisdiction to investigate on these grounds, and they can't issue any sort of sanction. Frankly, in my view, this particular provision doesn't make a huge amount of sense. I'm not suggesting this, but I think it would be arguably acceptable to just provide a blank copy to your employees, and they wouldn't be entitled to file a complaint about that. So right now, I think the legislation is a little bit toothless, but we'll see what happens. So I expect this is an important question for a lot of employers. How can you use the information that you gather by electronic monitoring? So the legislation doesn't create any privacy rights. It doesn't create any right to avoid or opt out of the monitoring. It doesn't restrain your monitoring in any way. And the amendments also don't limit your use of the data gathered in any way. Subsection 7 is explicit. Nothing in the amendments limit an employer's ability to use the information obtained. So by implication, if you gather information and you rely on it for disciplinary reasons, You're entitled to do that under the ESA, even if the data used and its purposes aren't explicitly set out in your policy. So if an employee approaches you and says, you can't use that data, you can't collect that data, it's not in the policy, they're wrong. But bear in mind, this is the ESA, and so this is the bare minimum. So no matter what statute says, your use of the data will still have to remain compliant with your employment contract and with the common law. So let's get into that a bit more. There's 3 points I want to make about use of the data. First of all, if your employment contract, for some reason, contains language about electronic monitoring, that's going to take precedence over whatever you have put in your policy. You have to remain compliant with that. Secondly, even if by the letter of the ESA, you don't have to tell your employees about the data you plan to collect and the ways you plan to collect it, our recommendation would be that you should. If you're going to collect data and use it against an employee, and that employee later on doesn't like it, they said it was improper, they take you to court, you're in a much better position to say that your conduct was reasonable and appropriate if you told them beforehand what information you'd be collecting and how it would be used. There is some case law which says employees are entitled to reasonable expectation of privacy over their correspondence, absent something in the contract or an indication from the employer. So by setting out your monitoring policy extensively and transparently, you're getting ahead of some of these potential issues. And then that said, the third point, you always still have to remain mindful of whether your conduct might actually be improper. Since the ESA basically says you can monitor however you want and use that information however you want, it might be tempting to craft a very aggressive policy, but please be careful. As a lot of you may know, the Ontario Court of Appeal has recognized a tort called intrusion upon seclusion, which is basically a legal claim that someone invaded your privacy. This tort was first recognized in 2012 in the Jones case, been affirmed in subsequent cases. So what makes you liable for intrusion upon seclusion? First, your conduct has to be intentional or reckless. Secondly, the invasion is into a person's private affairs without lawful justification. And lastly, a reasonable person would view the invasion as offensive and causing distress, humiliation, or anguish. This case and other cases indicate that viewing a person's banking records, financial records, medical records, images can qualify as an intrusion. So I'm sure you can see clearly how electronic monitoring, especially of a person's personal devices, might start ticking some of these boxes if you're not careful. A lot of the monitoring tools these days are quite fancy and quite powerful. The common law is clear that it's going to keep evolving to respond to changes in technology. The more sophisticated your monitoring tools, the more record keeping you maintain, the more intrusive it is, the more you're likely to be bumping up against potential liability. Also, the court in Jones didn't get into this at all, but I think there's vicarious liability for employers to consider. In that case, the defendant was a bank employee. She was using her employment position to view the plaintiff's banking records. So I think in a lot of ways, the bank was lucky they didn't get named as defendant. So all that is to say, the ESA's focus is on transparency, but as employers, your focus also needs to be on ensuring you're compliant with your contracts, with your common law, and that your monitoring isn't exposing you to any liability. As with much of employment law, if you do find yourself in litigation, the court is going to be concerned with whether your conduct was reasonable, and that's going to remain the case with electronic monitoring. Your use of common law aside, your use of the information has to be lawful. That means in compliance with other legislation. So to the extent that you are subject to other statutory privacy regimes, so I'm not going to say their full names, they're there, but the one FIPA, the other FIPA, PIPEDA, if those applied to you before, they still apply to you now. So more food for thought. I would assume that, since the tracking tools that are available these days are so comprehensive, so much data out there, I would assume that most executives and managers aren't actually aware of all the electronic monitoring capabilities of their workplace. So when you're drafting your policy, we definitely suggest you work together, not just with your employment lawyer, but also with your IT team to get the full picture of what's going on behind the scenes. And so I know we talked about this towards the start of the presentation, but I want to come back to it and finish with it because I think maybe it's the most important part of the whole discussion. So as you're turning your mind to what needs to be in your policy, what actually counts as electronic monitoring? I'll just give 3 more examples that I'm not too sure of myself. So in the design industry, for example, or in web development, it's common for projects to have extensive version history and changes tracked by every contributor who touches something. So what this really means is that if an employer wanted to, they could go and they could take a look at every single thing an employee did on a project, and they'd be able to say whether they contributed more or less than another employee. So is that electronic monitoring? As another example, take a supplier or a grocer or a warehouse, for example. Maybe they have no tracking of their employees directly, but they track their inventory, and they can use the inventory data to infer that an employee is stealing. Maybe they terminate an employee. So is that electronic monitoring employees? Is it by inference? I'll just give one final example, and it's something that myself, my colleagues, and many of you who are lawyers are undoubtedly familiar with. Lawyers are commonly expected to use docketing software to keep track of their time, their billable hours, and those records are subject to scrutiny and review by other members of the law firm. So just going by the definition, it's electronic, it could be used for monitoring. I think there's a good argument that maybe this should be in someone's policy, but can't help thinking this isn't quite what the lawmakers had in mind when they were contemplating the legislation. So anyways, I think there's a lot of room for interpretation. It's going to be interesting to see what the courts do with all this in the future, and definitely something for employers to be aware of now and on an ongoing basis. The final reminder, as Marty said, the date's coming up quick. You have until October 11th. If you need help crafting your policy, need help reviewing anything related to your electronic monitoring, please feel free to reach out to one of us. We'd be more than happy to assist. Thank you. So I believe we're going to take a little break here, 15 minutes, and we will be back at 10. Right, Marty?
Yep. All right. Thanks, everyone. We'll see you back at 10 o'clock. Thanks, Graeme. Okay. Welcome back, everyone, and let's move right along. I'd like to introduce David Heppenstall. David, the floor is yours.
Thanks, Marty. I'm David Heppenstall. I'm an employment lawyer and civil litigator at DSF, and I'd like to thank Mr. Marty Rabinovitch for inviting me to participate in this panel today. The purpose of this seminar is to answer a single question. Can language in confidentiality and conflicts of interest clauses render a termination clause unenforceable? And as a spoiler, the answer is yes. The court gave us this answer in the recent decision of Henderson and Slavkin. I'm going to take a little bit of a longer route to get to that answer, and here are the topics that we're going to cover on our way. First, I'm going to talk a little bit about the background of employment contracts more generally. We'll discuss wrongful dismissal. Back over to the contracts, we'll cover unenforceable termination language, restrictive covenants, and finally, we'll end up back where we started at the answer to the question with Henderson and Slavkin. By way of background for employment contracts, they're contracts, but they're not a standard commercial contract. It's governed by statute, the Employment Standards Act, and it's also governed by the various court decisions that consist of the common law. A modern employment contract does require all of the hallmarks of any standard contract, and that means we're looking for both offer and acceptance to exchange something of value, what we call as a legal term of art consideration. Generally, what's being exchanged is the employee is offering service and the employer is offering a wage. Any contract can be amended, but in an employment contract, if the employer wishes to significantly amend that contract, it cannot be unilateral or one-sided. The employer needs the employee's agreement. And this agreement cannot be under duress. So an employer cannot threaten to terminate the employee if the employee refuses to agree to the new terms. So for example, if the employee continues working anyway, that's not enough to be an agreement. Moving away from contracts for a moment to discuss wrongful dismissal law. This is a body of law that has evolved to mostly protect employees. However, employers are entitled to terminate employees without cause, provided that the employee is either given notice or payment in lieu of notice. So this would either be an amount of time designed to allow the employee to find a new job, or instead of that time, an amount of money to serve the same purpose. The notice period has two definitions, two prongs of the law. First, under the common law, the notice period is reasonable notice, and this will vary upon the context and the circumstances of the situation. Under statute, the notice period is a statutory entitlement that you can find in the language of the Employment Standards Act. The language of the Act are the bare minimum. They are the bare minimum employees' entitlements. An employment contract might specify something above that minimum. It could be greater than that entitlement upon termination, but it must be greater than what's in the Employment Standards Act. Neither the employee nor the employer can contract out of the Act. And these are those minimums. So in the Act, you'll find that if an employee has been working for under 3 months, there's no statutory entitlement. But beyond that, the number of weeks of pay or notice increase from 1 week to 8 weeks as per this table. If the contract, the employment contract, specifies an entitlement which is less than this amount, then that is absolutely null and void. And then you're out of the statutory entitlement and you're out into the common law notice, which again, the court will fix that time based on the circumstances. Switching back over to contract law, because there are other things that the employment contract could do beyond simply failing to specify an entitlement equal to or greater than the minimum entitlement under the statute. This case is not news, but I'm going to mention it as Waxdale, because Waxdale is the case that gave us this very important rule. If a with cause termination provision in the contract is unenforceable, then the entire termination scheme of the contract will likely also be unenforceable. If that termination clause is thrown out, then again, you're back out into your common law reasonable notice, which is generally probably going to be much larger than your statutory entitlement. A no notice if just cause provision is a famous example the courts use consistently, which renders all termination provisions in a contract invalid. So you might say that in the contract, the with cause provision is problematic, but the without cause provision is fine. But the problem is the rule from Waxdale says it doesn't matter. If there's a fault in any of the termination provisions, out goes the entire termination scheme. And even if the contract says that there's a severability clause, saying that if one part is found to be unenforceable, the rest of the scheme is enforceable, unfortunately, we also learn from Waxdale that it cannot be saved. Waxdale has been through the ringer. The Supreme Court of Canada declined to hear the leave to appeal from the Ontario Court of Appeal decision, so it's the binding authority in Ontario, and it's been followed by a large number of cases. For termination with cause, we look to the statute again, because in order to be disentitled from entitlements under the willful misconduct standard, which is in the Act, the employee must do something which is deliberate and knowingly wrong. And this is a high standard. This is why the just cause language is insufficient. It doesn't meet that high standard. So the employer must demonstrate that the employee purposefully engaged in conduct that they knew to be serious misconduct. And there's the language from the regulation in the Employment Standards Act. So to be absolutely clear, the threshold is an employee who's been guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. And I want you to keep that language in your head as we move forward. But for the moment, we're going to do a little side topic about restrictive covenants, another element that's going to be in employment contracts, or as an implied term within that contract. Restrictive covenants. These are provisions in the employment contract which restrains the employee's freedom, traditionally referred to as their freedom to trade. And these restrictive covenants are enforceable only where they're reasonable between the parties and in the view of the public interest. Some examples of restrictive covenants are non-compete clauses, non-solicitation clauses, and confidentiality. It's a discussion for another time about whether or not the individual restrictive covenants are themselves enforceable, and I have some notes here about whether or not the clauses themselves will be enforceable. And in particular, confidentiality, even if it doesn't appear in the employment contract, it's an implied term under an employee's duty to act with good faith and fidelity that the employee must keep the confidentiality of the employer's confidential information, such as trade secrets and so forth. And for greater clarity, exploiting confidential information to solicit clients is never permitted. That duty of confidentiality applies throughout the term of the contract, throughout the notice period, and after the employment ends. But back to the key here, what if that restrictive covenant clause includes termination language? And that's where we come to the Henderson and Slavkin decision. So let's talk about the facts. In 2015, Rose Henderson was a receptionist at a dental office, and her employers, contemplating retirement, asked her to sign a written employment contract because she didn't have a written contract before. She agreed and signed the new contract, and it did include a termination provision that limited her entitlements without cause to the minimums under the Employment Standards Act. And the court found that the termination scheme itself raised no concerns. But you can probably see where this is going. The contract's confidentiality clause and the conflict of interest clause provided that a failure to comply with those restrictive covenants demonstrated cause for termination without notice or compensation in lieu of notice. So here's what happened. The termination clause, and I'm not going to read the whole thing out here, mostly because the court found no issue. The plaintiff argued that this clause was not clear enough, but the court found that there was no interpretation of this clause that would find there to be an ambiguity or an inconsistency with the minimum entitlements under the Employment Standards Act. So the court says, nope, sorry, you look at the clause and it's fine. That ended the termination scheme. In a contract, you'll have a bunch of termination provisions, probably under a heading that says termination. But then over into the conflict of interest clause, this is where the court took out their elementary school red pens and started marking things up, because they found a significant number of problems with the conflict of interest clause. It began by stating that you agree that you will ensure that your personal interests do not conflict with the employer's interests, and further defined it as private or financial interest in an organization which does business or which competes with our business interests. And the court called this an incomplete sentence, and the employee would need to guess what words are missing to figure out what this conflict of interest actually means. And the next three all had the same comment. They were overly broad, unspecific, or ambiguous. For example, clause C, financial interests include the financial interest of your relative, a private corporation of which you are a shareholder, director, senior officer, so forth. Overly broad, unspecific, ambiguous. But the real problem comes at the end of all of these problematic, unclear terms, which states that a failure to comply with this clause constitutes both a breach of this agreement and cause for termination without notice or compensation in lieu of notice. So what the employer has tried to do here is saying that this is the threshold for termination with cause. This violates the Employment Standards Act, because remember back to the very clear language of the regulations under the Employment Standards Act, the threshold must be guilty of willful misconduct or willful neglect of duty. And breaching this overly broad, unclear conflict of interest clause fails to meet that standard. Similarly, over into the confidentiality clause. I don't need to read the whole thing, but it simply states, similar to what we stated earlier about the implied duties of confidentiality, during the performance of the employee's duties, they will acquire detailed and confidential knowledge of the business. And there's a long, lengthy clause which describes what the employee must not do with that confidential information. But the problem is it's a little unclear again, but the main problem, again, comes at the end, which states, in the event that you breach this clause while employed with the employer, your employment will be terminated without notice or compensation in lieu thereof for cause. So there you have it again, another with cause termination falls short of the standard of willful, not trivial, to support a with cause termination as required by the ESA. So there you have it. There are two clauses in the employment contract outside of the termination scheme itself that violate the ESA. So what happens? The court found that the conflict of interest and conflict of information provisions included those provisions which had termination language. They breached the act. And as a result, the court looked at it and says, well, this is Waxdale. This is exactly what Waxdale forbids. And the rule in Waxdale says that everything in the termination scheme is then thrown out. And that is what happened. Rose Henderson was awarded common law notice because the entire termination scheme was thrown out, not because of the termination provisions themselves, but because there were termination provisions thrown in to the restrictive covenants. The court then used a case, Wood and Fred Dealey Imports, to look at each of the termination clauses in the contract wherever they are found, whether inside or out of the termination scheme. And I won't read all 6 bullet points here, but suffice it to say that the same scrutiny is applied to any provision that talks about termination wherever it appears in the contract. Here's the main thought. The court's decision in Henderson is a cautionary tale for employers. A single clause that deals with termination anywhere in an employment contract can threaten the enforceability of a termination provision or scheme if it's not in compliance with the Employment Standards Act. Here's your key takeaway. Review, the rule of Waxdale is if any clause within the termination scheme is unenforceable, then the entire termination scheme goes out and you're into common law notice. Henderson takes the Waxdale approach and says that if any clause anywhere in the contract relates to termination, and if that clause is unenforceable, then the same rules apply and the termination scheme is out again, and you're into reasonable common law notice. My recommendation, have your employment contracts reviewed, I would suggest on an annual basis to ensure compliance with these developments in the law. For further reading on this topic, there's a blog post on our website at the link below. Don't worry about capturing it now. This will be available later on, but I'd like to thank you for your attention to this topic. And I'm now going to pass things on to my colleague, Mr. Timothy Gindi.
Thanks, David. I'm just going to get my share screen up here. And as David mentioned, my name's Timothy Gindi. I'm one of the lawyers at DSF practicing in employment law. And the topic that I'm going to talk about today is the Northern Regional Health Authority and Horrocks decision. It's the Supreme Court of Canada decision, relatively recent. And I'm going to discuss this case in depth as well as its potential application in Ontario. There is a lot of debate between employment lawyers as to how this case will impact Ontario in general. And the central question really is whether or not unionized employees are able to pursue human rights claims outside of the grievance process provided for in the Labor Relations Act. So before Horrocks, unionized employees were assumed to be able to pursue a separate human rights complaint outside of the grievance process, outside of their union, Separately, they could, for example, hire their own lawyer and submit a claim to the Human Rights Tribunal on the basis that there was a violation of the human rights in some sort of way. And so the Horrocks decision dealt with this issue, but they dealt with it in Manitoba. So turning now to the actual Horrocks decision. So the facts of the case are that Horrocks was suspended from work for attending while inebriated. Horrocks disclosed to her employer that she had an alcohol addiction. The employer required her.
I'm very sorry to interrupt you. I'm wondering if you might have some slides that you might have intended to share.
Oh, do you not see the slides?
To pull a Zoom cliche, no, we cannot see your screen.
Oh, I was under the impression you could see it. Let me try this. Can you see them now?
We can. Sorry to interrupt,
Perfect.
Tim.
Yeah,
Over to
no, thank you for interrupting, actually. I wasn't aware that you couldn't see it. So the facts of the case are that Horrocks was attending work while inebriated. She disclosed that she had an alcohol addiction. The employer required her to enter into an agreement that she abstain from alcohol and engage in treatment. And Horrocks refused the agreement and was subsequently terminated. After her termination, Horrocks' union filed a grievance, and her employment was reinstated on pretty much the same terms that she had refused to sign previously. And after her reinstatement, Horrocks was again terminated for alleged breach of the terms. So Horrocks filed a discrimination complaint with the Manitoba Human Rights Tribunal, and basically said that she was terminated on the basis of a disability, that being her alcohol addiction. Now, the employer disputed that the adjudicator had jurisdiction to hear the complaint, stating that there was a previous Supreme Court decision, which I put up there, and it stood for the proposition that a labor arbitrator had exclusive jurisdiction to hear labor disputes arising from a collective agreement, including human rights complaints. So the adjudicator at the Human Rights Tribunal disagreed, stating that the essential character of the dispute was a human rights violation, and that that she had jurisdiction to hear the case, and then went on to consider the merits of the case. So the employer applied for a judicial review of the decision on the basis that the adjudicator should not have heard the case for want of jurisdiction, that basically the Human Rights Tribunal did not have jurisdiction. And the judicial review judge found an error in the adjudicator's characterization of the essential character of the dispute and set her decision aside. The employee appealed to the Court of Appeal in Manitoba, and the Court of Appeal allowed Horrocks' appeal, stating that the adjudicator had jurisdiction to hear the case, and remitted the matter back to the reviewing judge to determine whether the adjudicator's decision on the merits of the complaint was reasonable. The employer then appealed to the Supreme Court of Canada. In a 6-1 decision, the Supreme Court stated that the adjudicator did not have jurisdiction to hear the human rights complaint. The court stated that the human rights legislation of Manitoba did not allow for concurrent jurisdiction of the Human Rights Tribunal. So effectively, the Supreme Court says that when you are a unionized employee, based on the Labor Relations Act in Manitoba, only a labor arbitrator can hear any sort of dispute that arises from a collective agreement. So the Human Rights Tribunal cannot hear a human rights claim. You've got to bring that through an arbitrator, and effectively you are barred from bringing it through the Human Rights Tribunal. The Supreme Court said that whether a dispute can be heard in the Human Rights Tribunal in general will be dependent on the fact. They said the central question was whether the dispute, viewed with an eye to its essential character, arises from the collective agreement. Now, the court did say that while this does not necessarily mean that every unionized employee dispute will fall under the sole jurisdiction of a labor arbitrator, a tribunal or a court will have to engage in a two-step analysis to figure out whether or not they have jurisdiction. And the first step is that a tribunal or court will have to examine the relevant legislation to determine whether it grants the arbitrator exclusive jurisdiction, and if so, over what matters. And the second step is if it's determined that an arbitrator has exclusive jurisdiction, then the next step is to determine whether the dispute falls within the scope of that jurisdiction. This will require analyzing the collective agreement and accounting for the factual circumstances underpinning the dispute. In this case, the court examined two pieces of legislation from Manitoba and found that because Manitoba's labor legislation had a mandatory dispute clause in the legislation, the legislator's intent was to ensure that all unionized employee disputes be heard by a labor arbitrator. And I'm going to tell you what that mandatory dispute clause is in a slide or two, and you'll see why the court came to the conclusion they came to. Furthermore, although the Manitoba Human Rights Code had broad, inclusive language to hear human rights disputes, it was not enough to support a finding that the tribunal holds concurrent jurisdiction or, parallel, so that it's a parallel stream that you can go through. So, I talked about the fact that we're going to speak about the application of the case in Ontario, and the case that the SCC heard was in relation to Manitoba, but it now begs the question, will cases in Ontario be dealt with the same way? For years, unionized employees brought human rights complaints in the Ontario Human Rights Tribunal. Does that now need to come to an end? So let's take a look at the applicable legislation. In Manitoba, firstly, subsection 78.1, every collective agreement shall contain a provision for final settlement without stoppage of work by arbitration or otherwise of all differences, and that's a key phrase there that the court focused on, of all differences between the parties thereto, or persons bound by the agreement or on whose behalf it was entered into concerning its meaning, application, or alleged violation. Now, taking a look at Ontario's Labour Relations Act, subsection 48.1, very similar provision, not exactly the same, but very close. Every collective agreement shall provide for the final and binding settlement by arbitration without stoppage of work of all differences between the parties arising from the interpretation, application, administration, or alleged violation of the agreement, including any question as to whether a matter is arbitrable. So, as I mentioned, the provisions, as you can see, are quite similar. They resolve all differences. The arbitrator resolves all differences between the parties. And that's what the Supreme Court talks about at paragraph 5 of the decision right off the bat. However, keep in mind that the FCC also said at paragraph 33 that an expression of legislative intent can still confer concurrent jurisdiction. The court went on to say, ideally, where a legislature intends concurrent jurisdiction, it will specifically so state in the tribunal's enabling statute. But even absent specific language, the statutory scheme may disclose that intention. The court went on to give examples such as the Canada Labour Code and the Canada Human Rights Act. So, for example, federally regulated employees may still have both avenues for human rights dispute. Justice Karakatsanis from Ontario, she was previously at the Court of Appeal in Ontario. In her dissent, she was obviously the sole dissenting justice. She gave examples of deferral clauses which were present in other statutes, but not in Manitoba's. She used Ontario and BC as examples of such deferral clauses, and specifically section 45.1 of the Ontario Human Rights Code and section 45 on the Ontario Human Rights Code. So starting with section 45, it says that the tribunal may defer an application in accordance with the tribunal rules. And then section 45.1 states that the tribunal may dismiss an application in whole or in part in accordance with its rules if the tribunal is of the opinion that another proceeding has appropriately dealt with the substance of the application. And the reason, that this sort of phrasing is important is because this is how the court sort of extrapolates in the legislature's intent. They take it from the wording of the legislation and then make a decision as to what the legislative intent was. Was it to provide concurrent jurisdiction, or was it to provide sole jurisdiction to a labor arbitrator? The Horrocks decision was considered briefly in a 2022 Superior Court decision in Ontario. I say briefly because it was effectively 2 paragraphs, and they weren't particularly long. So Justice Perel of the Ontario Superior Court held that as per Horrocks, labor arbitrators have exclusive jurisdiction over human rights allegations brought by unionized employees when the dispute arises from a collective agreement. The court in this decision ultimately held that the Superior Court did not have jurisdiction over the human rights claims of the plaintiff in this case, who was a member of a union. However, it's worth noting that no decision from the Human Rights Tribunal has addressed Horrocks yet, although it has been brought up, and specifically has not addressed Section 45 of the Ontario Human Rights Code. So now, what will be the future for unionized employees who have human rights complaints that do not want to bring it through their union, or cannot bring it through their union because their union has declined to bring it through, has declined to bring the human rights claim through the labor arbitration? So, I mean, notwithstanding and this is again my opinion, we don't actually have a definitive answer, but notwithstanding the decision in Lamb and Newman, it appears that Horrocks will not, in my view, bar an employee in Ontario from pursuing a human rights complaint independent of their union and outside of the Labor Relations Board. But at first glance, I can understand why someone may interpret this to say, well, clearly it seems that the court is barring unionized employees from bringing separate human rights complaints outside of the labor arbitration process. And in fact, Justice Perel says that. And so, my reading of the Supreme Court decision is a little bit different. I think that the Supreme Court is effectively saying that we need to first look at the legislative intent and then determine whether or not there is concurrent jurisdiction. I think Justice Karakatsanis, in her dissent, gives Ontario as an example of where she believes it's clear that there is concurrent jurisdiction. And so I think that, Justice Perel and Lamb and Newman was right to say, yes, the court doesn't have jurisdiction because the Labor Relations Act does not provide that jurisdiction. But I believe that the sort of rationale to get there was not either complete or there was sort of a misstatement of what the Supreme Court of Canada decision actually says, because the Supreme Court of Canada decision, in my view, says that you need to first look at the legislative intent. If we find that the provisions are such that they express a legislative intent to have exclusive jurisdiction with a labor arbitrator and not concurrent jurisdiction with a human rights tribunal, then there should be exclusive jurisdiction granted to the labor arbitrator. So we'll see, and I can tell you that myself and even my colleagues perhaps disagree on what the future holds for Horrocks and its application in Ontario. But the Human Rights Tribunal, I can tell you, does have a case where the Horrocks decision was argued, but they just haven't released a decision at this stage. And that concludes my presentation.
Okay, thanks very much, Tim, and thanks to all of our speakers. So we'll now move right into the question and answer period. So we do have a little bit of time now to answer questions. So thank you to everyone who has been submitting questions already. And we've also been answering a whole bunch of them in the Q&A box. As you've seen throughout the presentation. So if you have questions that you haven't yet submitted, now is the time to submit them. So let's see what else has come in for. So there's a question here: what weight will a confidentiality or non-competition clause hold if it does not meet the threshold in the ESA? Hypothetically, if an employee no longer wanted to remain employed, could they not breach the clauses to be terminated while receiving pay? Well,
I
right,
like this question. Sorry,
okay,
go ahead, Martin.
Okay, well, yeah, David, go ahead. Go ahead.
I like the question. It suggests that someone is trying to lawyer their way out of this. And actually, if an employee is attempting to intentionally breach the confidentiality clauses, that certainly seems like if there's conduct which actually does meet the Employment Standards Act, willful misconduct, willful and not trivial. And if it can be shown that the employee was engaged in that behavior, regardless of what the clauses are in the employment contract, then that doesn't necessarily mean that they're going to be receiving pay in lieu.
So, yeah, I'm just going to weigh in here on that question as well. So, I mean, in terms of, I mean, if we're not answering exactly, Aaron, what you'd like us to, I mean, feel free to submit a follow-up here. But first of all, in terms of what is an appropriate confidentiality clause, that's not really something that's addressed in the Employment Standards Act. I mean, employers will typically define what sort of information they believe and want treated as confidential. And if an employee discloses that information to a third party or someone that they're not supposed to, then that could result in discipline and possibly termination. Now, again, you know, in terms of the termination, you know, whether it's, you know, for cause, without cause, for willful misconduct, that's all going to depend on the facts. And then in terms of non-competition clauses, I mean, David touched on this a little bit in his presentation. So, I mean, just to be clear about non-competition clauses, so the common law on those is very, very employee friendly. Okay, in other words, it's very, very difficult for employers to have an enforceable non-competition clause. Then we have the amendments to the Employment Standards Act, which effectively said that you can't have a non-competition clause unless you're dealing with a C-suite level employee, so the CEO, the COO, the CFO, and probably some others. The only other exception would be about a sale of a business. So if you sell your business and you receive the purchase price, and the company that bought your business wants you to have a non-competition covenant, then that will probably be enforceable. And I mean, if this is sort of a situation you're thinking of where the employee basically just wants to, I don't know, upset the employer to get fired, and, you know, hope that, you know, the firing, you know, would be, you know, without cause, and for them to get a severance package, I mean, fair enough, but you know, the employer just has to be diligent about dealing with that. So you know, you discipline employees who breach, you know, your policies and breach their obligations to the employer, and you consider whether or not, you know, there's just cause or willful misconduct for the termination. Okay, let's move on to another question. Now, this one is about Graeme's topic here. So Graeme, I'll let you weigh in first. This one says, how long do you have to keep records regarding the electronic monitoring policy? I'm not sure if that's expressly in the statute. Graeme, did you want to weigh in on that one? Oh, Graeme, are you muted? There you go.
Sorry about that. So I think it depends exactly what kind of data you're talking about. In the statute, in the guidance, actually, you have to keep copies of the policy itself for 3 years after that policy is no longer in effect. If you're talking about the data you collect, you'd have to consult the relevant privacy law that you might be subject to, because there's different retention times depending on the type of data and the situation and what circumstances that it's collected under. So if you can ask more specifically, might be able to answer you a bit better.
Yeah, if there's specific pieces of information that you're wondering about, yeah, you can always connect with Graeme or one of us offline here. Okay, can we elaborate on a contract signed under duress? I'm happy to start with that one, and then anyone else can weigh in here. Well, I mean, if an employee is seeking to avoid, I guess, the effects of a term in a contract that they don't like, one of the possible ways of getting around that would be to try and establish that the contract was signed under duress. I mean, the other possibilities are things like unconscionability or undue influence and, lack of consideration, which I think David talked about. But I mean, with respect to duress specifically, if that's something that the employee is going to argue, I would just say that the burden would be on them to establish that, and that it's generally quite difficult to prove. Does anyone else on the panel want to weigh in on that?
I mean, I think you're going to have to establish something serious, like some sort of fraud or complete misrepresentation or some sort of, something quite serious in order to say it was signed under duress. Like, you've really got to show a situation that is more than just, well, I want my job or I wanted the pay. It's got to be something beyond that.
Yeah. It's like undue pressure, essentially. It's a very, very high threshold. Okay, Graeme, I think this one is for you first. In regards to the electronic monitoring policy, would it need to cover security camera footage that is used solely for health and safety purposes and not saved or monitored? Interesting. What do you think, Graeme?
Yeah, next question, Victoria. I mean, it's a good question. I mean, I think it depends exactly what's going on. So if you have a camera and it's not plugged in, or no one's actually ever looking at the video feed, and it's not recorded anywhere, then maybe there's actually no monitoring going on. But if there's a screen in a security room somewhere, someone could actually look at it from time to time. The guidance from the ministry is clear that health and safety, that's a purpose that sort of they want disclosed. So, I'd say you may want to put that in your policy.
Okay, David or Tim, any other comments on that one?
No.
Okay. Okay, if we engage a third party to monitor employee email usage, Graeme, your topic is very popular today. Would we need to name the third party in that policy disclosure or keep it generalized? Graeme, to you again.
Yeah, I don't think you have to get that specific in the policy. That they say that you may, based on what the guidance says, you might have to indicate that you do use a third party service, and that the employee emails are monitored. But I don't think you actually have to name the third party that you've engaged.
Yep, I agree that the point is to include in the policy, how the employees are being monitored and, what sort of use you're making of the information. But yeah, if you're using a third party, you could say that, that there's monitoring here. But yeah, I don't think there's any obligation to name a third party. Graeme, again, does the electronic monitoring also apply to GPS in vehicles for a fleet?
It would. I think so. I mean, if you have people in those vehicles, then you'd be able to tell where your employee is by checking the GPS in the vehicle. So I think that would go in your policy.
Okay, let's keep going here. Graeme, again, my gosh, Tim and David, feel free to weigh in here too. Given the lack of clarity with respect to what Graeme rightly deemed passive monitoring, would it make sense to define it that way in a policy and perhaps explicitly explain the circumstances in which it may become active monitoring, like accessing previous info from the cloud to determine whether something took place? What do you think?
Yeah, I mean, I think that if you have all this information in the cloud, and if at any point you might want to actually go and look at it, then it should be in your policy that that's a possibility that could happen. If you have all this information and you never plan on ever looking at it again, then I think arguably you could just leave that out of your policy. But if you're going to, then I think what you say makes sense to, yeah.
Okay. Yep. Sounds good. All right. We are doing very well here with the questions. Let's keep going. Let's do that one. Oh, here's one about my topic, it looks like, regarding idle. Can you please clarify if employees are entitled to 3 paid days off for each COVID-related time off? No, it's a total of 3 days is what the ESA is saying. And the second part also, these 3 days off, 3 days are on top of the company provided paid sick and personal days off. So my understanding of it, and we may have to double check on this, and any of my colleagues can help me too. My understanding is that if the employment contract is already providing something like 10 paid days off, that is going to meet this requirement, and I don't think there would be an entitlement to an additional 3 days off. Tim, David, or Graeme, any insight on that? Or no? Okay.
Nothing beyond that. No.
So Oksana, maybe just if you send me a quick email, we can double check on the second part. But yeah, probably if you have a contract that already provides for at least 3 paid days, I don't think the employees are going to be getting additional days, but we will check on that for you.
I believe it's a total of 3. I think that's right.
Well, total of 3, but yeah, we're saying, what if there's an
per infection?
Yeah, if there's an employment contract that says they get 10, is it 10 or 10 plus 3? I think it's 10, but I guess
no. I believe the guidance says that it's 10. That
yeah.
It would be the 10. It wouldn't be 10 plus 3. I remember I read something about this recently.
Yeah. Okay. There you have it. Thanks, Oksana. Good question. Okay. Okay, for employees who work from home, what is considered reasonable monitoring versus invasion of privacy? Well, that's yeah, we could probably spend an entire seminar on doing that one. But Graeme, what's your answer to that one?
Yeah, no, I mean that's really the question in a lot of these cases, right? Whether your intrusion was reasonable. I think it would depend what your what your employment contract says, what the context is of the workplace, how much they're already monitored on a day-to-day basis. I think it's hard to answer a question that broad. Maybe it would be easier to sort of discuss this offline, or go up with a
What I'll just say too is, if we're looking at what's reasonable and what's not, I mean, if you disclose in this policy that Graeme has been talking about what it is that the employer wants to do or plans on doing, there's a much greater likelihood that it's going to be seen as reasonable. So if you have a policy that says, well, all employees are required to install this program on your computer, and we are going to be monitoring the time at which you log in, the time at which you log out, we will be notified for any periods of time during which you are not at your workstation for 20 minutes or more, and we are going to be using this to make sure that all of our employees working from home are working productively. Okay, if that's your policy and that's something that the employer does, probably at the end of the day, if there were a dispute there, that is going to be considered reasonable. Okay, what else do we have here? Okay, this one I think is for you, David. Am I to understand that a defect in one provision of a termination clause of an employment agreement negates all other aspects of all the criteria for termination without cause, which would then allow for severance pay under common law, or what can I say, common law reasonable notice, where it may otherwise not be applicable? That one is all you, David.
Thanks, Clive. Your understanding is correct. What Waxdale tells us is that you don't read an employment contract in piecemeal. You don't look at one sentence, look at this part, and then piecemeal take certain parts out. Waxdale tells us that even if the provisions are under a section labeled termination, if any provision anywhere in the contract, like we know from our most recent case, all of that together is the termination scheme. So all of the aspects, all the criteria, all of the consequences, everything. If you read the termination scheme throughout the contract together, and if that scheme violates the Employment Standards Act, then you're out of the statutory entitlements and you're into your common law reasonable notice entitlements.
Okay, thanks, David. Yep, sounds good. All right. If you suspect an employee has fraudulently provided a doctor's note and claims they were told to take 2 weeks off for COVID after being rejected for the time off request by their manager, do we pay this or no and investigate? Well, I mean, if the starting point is, I mean, employers aren't really permitted to second guess the content of a medical note. You can't say, well, that just seems wrong, and we're not going to take any steps to accommodate you because we just don't agree with your doctor. It depends what you're really getting at by fraud, I think. I mean, if you mean that the note is effectively forged and wasn't actually provided by that doctor, I mean, sure, you could call the number on the note and say, hey, Mr. Smith presented me with this note. We just want to make sure that it in fact came from your office. So I think you could investigate, in that regard. In terms of, I mean, if what you mean is that the content of the note effectively seems a little bit suspicious, if the note is ambiguous in terms of what sorts of accommodations are necessary, or there's conflicting medical information, then there may be a basis to request that the employee go see a specialist or attend at a third party independent medical examination. So those are the sorts of things that could be done. It's going to depend a lot on the facts, but those are some of the considerations that I think are important. David or Tim, did you want to weigh in on that one? Tim, maybe? Anything?
No, yeah.
Okay.
I'm actually looking at, there's another question about the 3 days and whether or not it would be in addition, the 3 days sick leave.
Okay, so sorry, so there's nothing further on the one that we just talked about, so we'll move on from that one.
No, yeah,
okay.
I think.
So yeah, Tim, go ahead with the 5+3. I see that one now.
Yeah, so like I'd mentioned, I think if your contract provides for something more than the requisite 3 days, then you're covered. You don't add the 3 days. I'm actually just taking a quick peek to see if I can find the guidance on that, which had specifically said that, but I believe the correct answer is that you would get a total of 5 days, not 5+3. If I can find the actual answer and highlight it from the guidance that the Ontario government has provided, I'll post it.
Okay, we will. Yeah, if we find something specific, we'll tell you. But yeah, at least for now, Tim and I seem to be in agreement that we're not adding the extra 3 days.
Right.
Okay. We've got time for I think a couple more questions here. Let's just see what has come in here. So okay, here's a good one in terms of terminations provisions. Let's answer this one. So I'll start with David. So how do you recommend we update all employment contracts with the new termination wording? Do we do a new employment contract at the anniversary? So David, why don't you start with that one?
Certainly. So whenever you are, as I mentioned in my presentation, whenever you're amending a contract, it needs to be done with the agreement of the employee. But at the same time, in order to have consideration in the contract, there needs to be something that you are offering in exchange for their signature. And so not just at the anniversary, but perhaps if it was in exchange for a raise, doesn't even need to be a substantial raise, but there needs to be something new in the contract for the employee to agree to if you want to sneak in those new terms to make sure it complies with the Employment Standards Act. And I shouldn't have said sneak, I meant revise.
Okay, thanks, David. Anything else, Tim or Graeme, on that one? Okay, let's take, okay, so let's take one more question here, and then we will wrap up. Okay, let's do this last one here. So if a contract contains a restrictive covenant such as a confidentiality clause that is vague or too broad, that warns that breaching it results in termination or may result in termination, would that still violate the ESA termination provision if the clause does not specify the type of termination or does not guarantee termination? Well, I'll just comment first and just say that, yeah, it really is going to depend on the actual wording in terms of what the answer is. But David, did you want to make any more general comments about that? Or
yes, this is basically exactly what happened in the Henderson decision. And I see how you're ending your question by saying it doesn't specify the type of termination with cause or without cause, but by simply the way that it's being laid out here, if you terminate if you violate the confidentiality clause, then you're terminated, then that's a cause. So you can't say you'll be terminated without cause, but that's the cause. But to go back to what Marty said, it is really going to depend on the language of the termination provision. But certainly you have to be careful that if there is something in the contract, wherever it may be, and if it is a threshold which isn't the same as the threshold in the Employment Standards Act, then there's going to be a violation and the whole scheme might be unenforceable.
okay, anything else on that one? Okay, let's actually, all right, you know what, I think unfortunately we're running a little bit tight on time. So for the unanswered questions, you know, we will make a note of these and we will get back to you. And just a reminder, we can't give specific legal advice here. So I think there's a question specifically about economical and DoorDash, and that one I think is better addressed offline, as again, we can't give specific legal advice here. But in any case, I did want to make a few concluding remarks. So I wanted to thank everyone for attending this morning. And thank you to our speakers for attending. I thought all the presentations today were great, and we're very informative. So some of you in attendance today, I think, have been attending these seminars regularly. Others, this might be your first one. So we just wanted to let the newcomers know and remind the experienced DSF employment seminar attendees know that we typically host these seminars usually about once every 3 months. So watch your emails for the next seminar, which will be coming up soon. We do appreciate any feedback that you might have about the seminars, and in particular, if there are any topics that are of interest to you that you would like us to speak about in the future. By all means, send them to us, send them to Fawzon, and we will certainly consider all suggestions when we are coming up for topics in the future. So I do want to say a little bit more about our firm as well. So you've heard from a number of our employment lawyers today, but Devry Smith Frank is a full service firm. We do have offices in lots of different places, Toronto, Whitby, and Barrie, to name a few. So if you do need to have those employment contracts reviewed, remember, once a year, or if you do need a policy about electronic monitoring, or if you're a unionized employer and you've got a unionized employee who has filed a human rights complaint against you, don't hesitate to contact us. But we are a full service firm, so we are happy to assist with any legal needs that you might have. So once again, thanks very much for joining us. If you would like a copy of the slides, again, you can either email us and we'll send you the complete deck. They will also be available on the website. There was also a question about access to the recording of this webinar. I'm told that the recording will be available on our firm's YouTube channel pretty shortly as well. So feel free to have a look there. And I know that David mentioned that there was a blog available on his topic, and I think that has already been posted as well. So you've got all that good stuff to look forward to. All right, everyone, thanks very much and have a great day. That concludes today's seminar. Bye now.
All right.
Thanks all.
Bye.